afternoon and welcome to the thorough newspaper analysis for 4th July 2022. So today we have one editorial article which has been taken from the Hindu newspaper and it is titled as Technology is no panacea for custodial deaths. Following that, we will have the news update and the legal news, which you know are a part of LawSikho's initiative to keep its readers and students updated with the current affairs that is happening in and around of India, so that you will find an edge when you sit for your competitive exams and judiciary exams alike. So for today's article, which talks about technology is no panacea for custodial deaths, it is in light of the fact that India has a very grim record in police brutality and custodial violence. Now, between 2001 to 2018, 1727 persons died in police custody, but only 26 policemen ended up being convicted due to these custodial deaths. Now, the question that arises here is how technology can be used in police proceedings, namely interrogations. Now, when we talk about custodial violence, police brutality, or even custodial death, this is primarily because a lot of the times during interrogation or investigation, the police involved in the said investigation or interrogation lose their patience and they beat up the alleged person brutally. Now, this leads to them retaining very serious injuries, which may cause death, or even if it does not cause death, it does cause them permanent damage or disfiguring. So in light of that, a lot of people have been claiming that we can use technology instead of police. And these technologies will run on artificial intelligence and will be backed with machine learning so that they can be used as more efficient instruments in an interrogation. So given the prevalence of custodial deaths, technology is now being considered as the silver bullet by many. And these include body cams and automated external defibrillators. Now, what are body cams? Body cams is something that was brought up during the movement of Black Lives Matter, as we know. So there's a small camera that records everything that a police sees. It is attached to the uniform and it keeps on recording. It can't be stopped, or like the recording can't be tampered with by the police himself. So it helps in bringing a clarity that in case someone does allege that yes, a particular policeman or a particular group of police went forward and harassed someone, the body cam would then come to show the evidence that whether the actual incident being claimed had occurred or not. Now, deception detection tests also exists when we talk of technology for interrogations. Now, these are like narco tests or polygraphs or brain mapping. Now, these two are innovative technologies that aid investigations. However, back in 2010, the Supreme Court in the case of Selvi versus State had held that such evidence was not admissible, and brain mapping or narco tests or polygraphs without the consent of the alleged incarcerated was a violation of their fundamental rights. The risk of using artificial intelligence and machine learning also exists. While we do agree that technology can be brought in to aid the police during investigations and interrogations, it is true that there are certain inherent problems that will come when we bring technology into this. Now, three of them that we can point out are the main two are there exists a risk of bias, and the machine learning due to this inherent bias may keep targeting particular communities and individuals. Thirdly, and this is compared to the above two, this is considered a lesser problem, which is automated interrogation techniques are not accurate. That is, they may often not appear ethical. Now, custodial deaths ought to be cracked down firstly with stringent force as per the guidelines issued in the case of DK Basu versus the state of West Bengal in the year 1997. Hiding behind technology is not a proper excuse. Enforcing the right guidelines that have been stated by the judiciary and legislature is the only permissible way of preventing custodial deaths. Further, the draft bill Prevention of Torture 2017 that was supposed to be raised has yet not seen the light of day. As duty-bound legislatures, as responsible legislative members, the parliament is supposed to bring this up, revive this Prevention of Torture 2017 bill, and ensure that the same is passed and the guidelines given in them are adhered to by the police. Following that, if any police goes against these and indict brutality upon an incarcerated or upon an alleged person, strict actions should be taken against them. So here you can pause the video and let me know what were the guidelines that were stated in the case of DK Basu versus the state of West Bengal 1997. Please let me know in the comments below. Now, for the news updates today, we have the first news of today, Digital India Week 2022. Now, the Digital India program was launched back on July 1st, 2015 by the Honorable Prime Minister of India with a vision to transform the country into a digitally empowered society and knowledge economy. Today, India boasts of the world's third highest number of startups, with new unicorns sprouting almost every week. Post the pandemic, India has emerged as the preeminent nation in the use of technology for a resilient economy and governance. Secondly, we have the 125th anniversary of Alluri Sitaram Raju. Prime Minister Narendra Modi will launch the year-long 125th birth anniversary celebration of legendary freedom fighter Alluri Sitarama Raju at Bhimavaram in Andhra Pradesh tomorrow. Now, Prime Minister will also unveil a 30-foot tall bronze statue of Alluri Sitarama Raju. Thirdly, Maharashtra Assembly elects new speaker. Narvekar, who polled 164 votes, defeated Uddhav Thackeray-led Shiv Sena candidate Rajan Selvi, who got 107 votes. Narvekar, who is aged 45, is said to be the youngest ever assembly speaker in the country, said Deputy Chief Minister Devendra Fadnavis. Narvekar's father-in-law, Ramraje Naik Nimbalkar of NCP, is also the chairperson of the Legislative Council. For the legal updates today, we have application for further investigation can be filed even after commencement of trial, and the same has been held in the case of Ganesan versus SHO and another by the Madras High Court. So while allowing a revision of the order, the Madras High Court recently observed that an application for further investigation can be made even after the commencement of the trial. Bringing out of the truth was of the utmost importance, and provisions of section 173 subsection 8 of CRPC does not put any fetter on the police to conduct further investigation in this regard. For the second update today, we have cancellation of bail. Cancellation of bail cannot be limited to the occurrence of the supervening circumstances, and this has been held by the Supreme Court in the case of Deepak Yadav versus the state of UP. So while dismissing the bail application, the SC observed that HC had not taken into consideration the criminal history and the material evidences that were relevant and available for the particular case. So this was all for today. For free study materials and TNA PDF slides, please join our Telegram channel, the link of which you can find in the description below, or you can always go forward and scan the barcode given on the screen at the Law Test Prep. You can also join our official Instagram channels, LawSikho.Judiciary, LawSikho CLAT Prep, and UGCnet_LawSikho. For any further information, please feel free to visit www.lawsikho.com. Thank you.